So, you might have heard of Constitution Day. It's that day in September when we're supposed to remember a bunch of guys in wigs signing a very old document back in 1787. And it's easy to think, okay, cool, history. What does that have to do with my life? I argue with my phone's AI assistant. I worry my delivery drone is judging my snack choices. But here's the thing. The U.S. Constitution isn't just a historical artifact collecting dust in the National Archives. It's a living, breathing set of rules that we are constantly arguing about. It's the operating system for the United States. And like any good OS, it's always getting updates. Not through new code, but through new interpretations, new arguments, new court cases. It's a work in progress, and we are all part of that progress. The framers, for all their powdered wigs and pre-internet wisdom, couldn't have imagined global networks, or artificial intelligence, or a climate crisis that threatens coastlines. They wrote about the right to be secure in your papers and effects. But what does that mean when your papers are petabytes of data stored on a server you've never seen? Let's talk about the Fourth Amendment. It's the part of the Constitution that protects you from unreasonable searches and seizures. The idea was to prevent the government from, barging into your house and rummaging through your stuff without a good reason and a warrant. The framers were thinking about physical spaces, your home, your papers, your belongings. But today, our entire lives are stored on a device that fits in our pocket. Your smartphone contains your private conversations, your location history, your financial records, your health information, and your most embarrassing photos from 2017. Is that little glass and metal rectangle a paper or an effect? Is it a house you carry with you? The answer is a resounding, it's complicated, and lawyers are making a lot of money arguing about it. For years, the courts struggled with this. One key idea was the third-party doctrine, which basically said that if you voluntarily give your information to a third party, like a phone company, an internet service provider, you lose your expectation of privacy. That made sense when it was just about who you called. But in 2025, it applies to almost everything. Your location data is held by your mobile carrier. Your search history is held by Google. Your direct messages are held by Meta. Under a strict reading of that old doctrine, the government could potentially access huge parts of your digital life without needing a warrant, because you voluntarily shared it. It's a legal loophole big enough to drive a data mining truck through. However, the tide has started to turn, thanks to some landmark Supreme Court decisions. In the 2018 case Carpenter v. United States, the court recognized that your cell phone location data is different. Chief Justice John Roberts wrote that tracking a person's movements for months on end provides an intimate window into a person's life, and accessing that information constitutes a search under the Fourth Amendment. This was a huge deal. It was the court saying that the old rules might not apply to the digital age. They acknowledged that carrying a smartphone isn't really a choice for most people. It's a necessity for modern life. You aren't so much voluntarily giving up your data as you are just existing. So where does that leave us in 2025? The debate is far from over. The Carpenter decision was specifically about historical cell site location information. It didn't address real-time tracking data from apps, your search history, or the vast amounts of information collected by smart home devices. All right, let's switch gears from what the government can see to what you can say, or, what an algorithm can say on your behalf. The First Amendment protects freedom of speech, which is pretty straightforward when we're talking about a person standing on a soapbox in a public park. But what about an AI model that generates text images, entire political campaigns? Does computer code have free speech rights? This question might sound a little ridiculous, but it's at the core of the debate over how, or even if, we can regulate artificial intelligence. And believe me, in 2025, with hyper-realistic deepfakes and AI-driven news feeds, this is not an academic exercise. The argument, put forth by some tech companies and free speech purists, is that code is a form of expression. An algorithm, they contend, is just a set of instructions written by a human, reflecting the creator's choices and priorities. Bias data output a person speaking. The conversation around AI and the Constitution doesn't stop with free speech. It runs smack into the 14th Amendment, which guarantees equal protection of the laws. This principle means the government cannot treat people differently based on characteristics like race, gender, national origin without a very, very good reason. But what happens when the government isn't a person, but an algorithm? In 2025, governments at all levels are using AI and automated decision-making systems for everything from determining who gets bail, who qualifies for social benefits, and even how to deploy police forces. And a huge problem has emerged. These systems can be deeply biased. The issue is that AI systems learn from data, and the data they learn from is often a reflection of our own society's historical and systemic biases. For example, if an algorithm is trained on past arrest data to predict where crime is most likely to occur, it will likely learn to send more police to minority neighborhoods that have been historically over-policed. This creates a feedback loop. More police lead to more arrests, which proves to the algorithm that its prediction was correct, leading to even more policing. Of all the constitutional debates, the one over voting rights is perhaps the most fundamental, because voting is the mechanism through which we, the people, hold all other rights accountable. The Constitution originally left voting rules mostly to the states, which led to centuries of exclusion. The 15th Amendment, prohibiting denial of the vote based on race. The 19th Amendment, extending voting rights based on sex. The Voting Rights Act of 1965 built a national standard for suffrage, but in the 21st century, and especially in the years leading up to 2025, the battle over who gets to vote and how has become fiercely contested again. The central constitutional tension lies in Article 1, Section 4. It gives states the power to set the times, places, and manner of elections, versus the federal government's role in protecting the right to vote from discrimination. This tension exploded in 2013 with Shelby County v. Holder, which gutted a key pre-clearance provision of the Voting Rights Act. That provision required certain states with histories of racial discrimination to get federal pre-clearance before changing election laws. So, after diving into digital privacy, AI regulation, voting rights, it's pretty clear. The Constitution is anything but a dusty relic. The framers gave us a blueprint, but they didn't, and couldn't, give us all the answers. It will be decided by us. The Constitution is a conversation. It's our turn to speak.